Good morning on the West Coast and good afternoon on the East Coast. Today is Wednesday, April 19th, and it's a beautiful day to have a webinar. I'm John Yarrington, CEO of the Performance-Driven Marketing Institute, a 501c6 not-for-profit trade association dedicated to protecting, promoting, and advancing the direct-to-consumer and direct response advertising industries. And on behalf of the entire PDMI team, it's my pleasure to welcome you to another fun-filled and exciting episode of the PDMI Take 20. As a reminder, the PDMI Take 20 is a quick-hitting roundtable discussion led by industry experts on trending topics, all in 20 minutes or less. Today, we're joined by an incredible guest, Mr. Legal and Tort Advertising himself, Adam Warren of OpenJar Concepts, and we'll be discussing the latest in legal and tort marketing. However, before we get started, please allow me to do a little housekeeping. If you'd like to ask a question, and we encourage you to do so, please use the questions tab located in your control panel. Also, please note we'll be taking questions throughout today's conversation, but we'll be holding replies to the end of today's discussion. Alrighty, folks. With that said, please allow me to take a moment to introduce today's moderator. His 2 cents is worth $38 and change. He's the fearless Chris Foster. Chris is Vice President of New Business at Modern Postcard, a direct marketing agency located in Carlsbad, California. In addition to his day job, Chris teaches brand strategies at UCSD extension courses, and he's the chairperson of the Brand Response Council. As always, Chris, it's a pleasure to have you here today. Thank you for all you do. And for the 63rd time, because this is our 63rd episode, take it away, my friend.
All right. Well, welcome in, everybody, and happy Wednesday to you all. Yes, we are in season 3 of Take 20, and so glad to welcome Adam to episode 63 for his very first time for Take 20. I doubt it will be his last. So what we're talking today is about legal and tort marketing, because attorneys not only need to settle complex cases for clients, they also need to market as well. In a fragmented media environment, it's more important than ever to understand how to mix different channels to get the most positive presence. From billboards to linear, CTV, and more, the challenge for law firms is to carefully balance a variety of impressions to create the right intake process so they can turn those impressions into leads and clients. But as we all know, with every industry, the best practices have changed. So we're going to talk about what's new, but what's consistent, and those marketing third rails that you should avoid, and really apply this to any PI or tort lawyer service that's out there. So joining us is Adam Warren, CEO, co-founder of OpenJar Concepts. They are an award-winning hybrid performance media and advertising agency. So Adam, we're going to start off with the first easy kind of description of the landscape. What are the major differences that you have to guide clients through between marketing for PI versus tort or class action that really impact your media and your marketing strategy?
Well, when you're talking about mass tort, it is typically a nationally focused campaign. The thing about when it comes to drugs or defective medical devices, there are no borders. So every campaign qualifies nationally. Now, there are some states that don't like it. They don't want you to come into their state and market through their local channels. However, when you're running on a national broadcast or cable network, if you're doing syndication, you cannot control that. So typically our workaround is just don't go into those blacklisted markets where you're going to get harassed and buy their stations. Can someone from a local bar in those states identify the difference? No. But if there was ever an audit, it's easy for us to prove, well, yeah, we avoided your state, but there is no technical capability for us to run nationally and avoid your state. So we have other ways of dealing with that. And typically that happens at the intake level, where if we have to say so, sorry, thank you for calling, we don't service your state. When it comes to personal injury, there are some movements to become nationally focused. And that is a complex endeavor, because to become national, if you're the host of the campaign, if you will, you've got to be able to make sure that whoever's hosting the campaign has co-counsel in every state. We'll allow some hit listing of state, right? But a national campaign to us, we start losing interest after about 40 states, or anything less than 40 states. So if you knock out, look, I've got 10 states I just don't have in, okay, we can generally work with that, but you just have to be careful and measure the ROI very quickly, because 10 states is 10 states, and that's a lot of people, and a lot of potential respondents. So there's a big difference then to how we approach what we would call single event. Personal injury is one part of the localized side of legal marketing. There are plenty of other case types that we would only market in a specific state, and that's a lot of what we do. We work on really difficult niche cases, and those types of cases locally are not going to require thousands of cases in the docket. I've had campaigns where if I get 5 cases, they're thrilled, because each of those cases are massive in payout, and they have other things going on in the background about how settlements are being negotiated, and they need a finite number, and that's it. So there's a lot of moving parts between a mass tort and a personal injury or other type of single event that make them fairly uncomparable.
That makes complete sense to me. So I guess one question is, you start flexing your strategy based on whether it's national, whether it's local, whether it's PI or tort, or a variety of different case types, you also have to adjust on the media side. So firstly, congratulations to OpenJar for winning 22 and 2023 Golden Gavel Awards for the 60 and 15-second spot. Well done on that. You won it for a 60-second spot and a 15-second spot. What strategy or approach had to change between those two formats, right? I mean, it's an interesting adjustment on your side.
Well, it's kind of a force feed on our side. So a lot of local attorneys, for whatever reason, are terrified to monopolize 60 seconds of time on their TV ad side. And I get it, because most attorney commercials that we've all seen have very little differentiation of one to the next. It's a lawyer on a green screen. It's standing in front of a bookcase. It's pounding on your desk. I wouldn't want to watch that for 60 seconds either. The thing that we have done is turned into brand storytellers. We want our clients to look at themselves like the brands they are. Just because they only exist in one state, maybe there's some that exist in 4 states, doesn't make them a less brand than what we see from insurance companies like Geico, Mercury, Allstate. Look at the quality of content that they're putting out to engage people to think about them when they need them. Lawyers have had to come a long way to understand that just because you run a commercial that says what a great lawyer you are, it doesn't mean that suddenly everyone's picking up the phone and running to call you. No, most of the time when they see you is not yet when they need you. And so we wanted to create content for these lawyers that was engaging, it was memorable, it was educating and entertaining, and it was branded. Because you and I hopefully never need a personal injury attorney. But what if we do? Who are we going to call? Well, most people in this country can't just pick up the phone and call their friend the lawyer. Fortunately, I can. Right? I've been working with lawyers for almost over a decade. We'll just say that. But most people can't. And therefore, in all likelihood, when you look at the kind of content that we see right now, they're going to pick up the first lawyer they see when it comes on TV, because they all look alike in terms of how they position their content. Maybe some have a cool jingle and that got you. But in most cases, it's going to be the lawyers that really take time to resonate with you that are going to get that call if you need to make it, and that's where we're focusing. So when we're preparing content, I always shoot from a 60. I then will cut down from that 60 into a 15 and sometimes 7 seconds, because they're going to get some social media content out of it as well. And we're able to make sure to maintain a targeted message from 60 seconds to 7 seconds. That never changes regardless of where we cut, but we want our attorneys to be available for every format possible to grab people's attention. Lower frequency will run on those 60s, higher frequency will run on 30 and below. But you mix some of that longer format storytelling in there to really give people the full picture of you, the chance to go write down your phone number, the chance to, take a picture of your QR code, whatever it is. They need that time, and we advocate that they take it.
Yeah, no, that makes a lot of sense. And when you talk about the brand storytelling, I think it's not like the law industry is immune to the basic tenets of really good marketing and branding, right? Any kind of personal service like that, whether you're a plumber, roofer, insurance broker, real estate lawyer, you are your brand, right? You're coming out and people have to believe in you as that entity. And so I love that storytelling approach. So can you talk a little bit about beyond just even video, as you start translating into other media such as digital and or billboards and or display or broadcast, how does that storytelling message adjust and change based on the format, or I should say the channel?
Well, I generally have to say TV formats of television. There's, how we define TV is probably another webinar, but
right.
I generally think when you're talking about TV in general, that is going to be your greatest creative lever. It's got the visual, it's got the audio, it's got everything, right? When you move to radio, you can emulate many of the core elements of that TV spot, but you've really got to try to do so to get into that listener's mind's eye, right? To try to see what you're projecting, but still keeping a message, right? Billboards, we do try to take a different approach to billboards. We understand people are seeing them in seconds. I know a lot of attorneys love to put their faces on the billboard. I like to put the occurrence that they're marketing for on the billboard, and I like to do it through, just eye-catching, very quick imagery. So, we don't feel like our billboards tend to look like most of what you see, and that's by design. I think for us, the message was, if we're going to market ourselves as a creative agency, as a full service agency, then we're not just going to get in and jump in the niche of design pattern that has already existed within this space. I'm not claiming that we've just created brand advertising as we know it. However, I am saying that we're innovating a style of brand advertising for this specific vertical of legal.
Right.
So what hasn't been par for the course for decades of law firm advertising, we are jumping into that. So there's all different kinds, and I want to back up and say, look, there is a market for the green screen advertising. There's a market for, walking through town and getting the lawyer's VO while he walks through his home or her hometown city. There's a market for that. I wouldn't say to not do that. I just think like we're all evolving in the kind of marketing we do, whether we're talking about various channels of media or not. I'm just saying keep evolving. Add more different styles of advertising, because inevitably, if you only do one type of marketing, you're going to hit one type of market. That's going to isolate your share. If you start to evolve the type of marketing you're doing to attract a different type of people than you've historically reached, you're going to enhance your market share. And it's hell for the local attorneys right now at that level. The competition is insane. They used to just be able to run SEO campaigns and PPC campaigns. No more. People want to know who they're doing business with. And in many of those cases, it's just too cold. It's too raw for people to say, well, I'm just going to pick this one because it was the #1 bar on my Google search. It's not really happening. Not at that kind of volume. And COVID was a big shift on that. And so now all the attorneys are COVID fighting for air.
Yeah, so I was going to ask you about that. So what are these big changes you've seen, post-COVID, and how do you see the best adaptation being most successful? Or I should say, what adaptation has been most successful?
Well, I'm trying to talk on both sides of the fence of tort and single event. So I think I've gotten into single event pretty good. And I'll keep coming back to it. On the mass tort side, it has become more complex than ever. The budgets have definitely gotten bigger. That has a lot to do with private equity money coming in.
Interesting.
Yeah, and private equity, angel funding, this is good and bad. The demands have changed at such a deep level to just talk to a law firm and say, yeah, I'll run your media and, you know, what's your CPA? That's not really applicable anymore. We have to understand beyond the intake what's going to happen. So we have to understand the price of the media, what happens on a conversion of that media to a signed retainer, what happens with that follow on to the retainer. A signed retainer is not a case. You don't throw that in your trunk and move on to the next one. That just means it's going on to another level. So then there's prove up, there's medical records, and if you don't have a good conversion there, the client's going to be coming back around and looking for you to replace. That's a whole another level of economics. So you've got to know economics all the way through to the very end and how that might double back and increase your cost load. So, you know, they want lower CPA goals. They want, you know, higher stick rate. They want.
They want higher conversions and to actually take that first initial impression through intake through those various stages. From a direct to consumer, a DTC language, you're talking about the customer journey. You're talking about the full funnel, right? Now, as you start becoming aware of it, you're actually doing full funnel marketing management for these firms.
Yeah, unfortunately, it doesn't end with a transaction of a product, right?
Right.
And maybe that you have to know your return rate if people are returning products and how that backs into your sales funnel. This is so complex. It could take months to actually know. Once you're already done spending, it could take months to actually know what happened with that campaign. So it's really not for the inexperienced at this point. I mean, the work we do with numerous intakes, we know how every intake converts. We know what type of media they convert best with. We know their stick rate, and that helps us then guide the law firm on who to work with based on what campaign.
That makes a lot of sense. Well, we are already at 11:25. I think that this could actually be part one of a two-part series of Tort and Legal. You've been
I talk a lot.
fantastic.
I drank too much coffee today.
No, but everything that you're saying, Adam, are these pearls of understanding and wisdom, and you're sharing your knowledge with what you know with the audience, and that's exactly what this is all about, and we really appreciate it. So, John, we are at
one thing. I don't want lawyers to watch this because they probably won't think I'm just like, hey, you guys, you know, you need to wake up. I will say, especially on the local level, they are some of the most savvy marketers. What their understanding of inventory is incredible, and opportunity is incredible, and how they're sometimes able to negotiate locally with media is really unparalleled. The thing that I think lawyers are now missing in their understanding is you're putting everything into inventory, start thinking about content, because we're in the age of content. And if you really want to win this game, that's what you need to be thinking about, because anybody can buy inventory. It's what you put in it that matters.
Yeah, and what's interesting is that they're all adept at telling stories in the courtroom, but it's very hard for them to tell a story about themselves, right? But that's the age old. That's the age old, but that's why you're there to help them out. All right, so Johnny, do we got questions from the audience?
We do, Adam. You got the phones ringing, buddy. Good job. I think we could do this for 4 hours today, but I don't know if we all have the time. So let me throw the first one at you. Annually, law firms nearly spend about $850 million in mass tort litigation. Hence, spending a firm's marketing dollars wisely is obviously incredibly important. Do you have any tips on how a firm can best select the right mass tort marketing partner?
Yes, they could call me. No.
That was like the softball of softballs.
Look, I think if you're a mass tort, if you're a law firm, you've got to consider the agency's tenure in the space. There are a lot of agencies that have singular offerings that are coming from lead gen that see there's a big gold rush on the mass tort side, and they are creating more havoc than good. What we need in this space are, they've got to look at tenure, they've got to look at the agencies that have a multi-channel offering. You know, you and I had some pre-conversation about a law firm wanting digital only. Like, no, you can't just, the law firms can't just dictate the kind of media they want to be in. How do they even know it works? And there are so many types of digital platforms. How do you choose just arbitrarily, well, I only want to do Facebook? Well, what if Facebook doesn't work for that campaign? So lawyers have to really be with marketers that have experience across not just TV, not just radio, not just digital, but across the full breadth of offering, how that applies to the campaigns that they want to run, because it is not always the same. However, it's very hard today to get meaningful and converting volume if you only depend on one marketing channel. Even if they came to me and said, I just want TV, I'd still be pushing radio in different digital formats. It's always going to work. They only want radio, I'm going to be pushing, right? So it's important that they understand how long their agency has been doing it, that their agency understands the front to back end, and that their agency offers a multi-channel option, because that's going to be required. It's not even a choice really anymore.
Correct.
Thanks, Adam. Here's a question that kind of builds off of the digital side of what you just shared. It says, what are you doing to drive leads online? What's working, what's not working? And by the way, do you have any experience with things working on YouTube advertising?
We've done some stuff in YouTube, and the YouTube stuff we have done is not what I would say is what we would traditionally do in other video formats. So for example, we'll work with an influencer, something like that, who's got maybe some credibility in that particular space, to get on there and do something that's engaging in the way people are used to consuming some information. But we're doing, it's, when I say we're doing everything, it's hard for me to kind of go through and pick each thing, but we're using digital that also drives phone calls. We are doing digital that of course drives the paper lead into the call center. We've got a lot of form fill and landers we build landers, landing pages for every single campaign we're in, and we may build them in multiples. And of course, you've just got to be, when it comes to digital, you've got to be infinitely concerned about TPA compliance, because it was a massive problem this past year due to Camp Lejeune. It was a volume like no one had ever seen, and it was just a powder keg of problems, because you've got people who are professionals at helping file complaints against you or your attorney for a TCPA violation that you didn't even know you were committing. So and in many cases you might not have, but then they also know it's cheaper to pay them off than to fight it. So you've got to be really careful about those things. You're not going to have those problems generally in TV and radio, but there are digital formats where they will get you, especially if there's outbound dialing that you thought was permissible. That's, you know, text can be very dangerous. You got to be careful there. And one of the big pitfalls that people were doing was saying, well, we've got their reg path and they registered here. Okay, well, they registered because they thought they were going to win a set of knives, not because that meant you were going to contact them for Roundup, right? It's very different. And so it might say in the terms and conditions, you're not just going to be subject to future offers of, you know, really cool cookware. We're just going to hit you for anything. It's so unreasonable that people are reading that and understanding that. It's now becoming a case problem where, at least for us, if there is a reg path for what people are engaging when it comes to outbound marketing, it is specific to that campaign and nothing else. And that's really one of the only ways to protect you.
Thanks, Adam. Let's do one more. I think we got time for one more. And this is a two-part question, and it's kind of state focused. So hopefully you've got some expertise in this area. It says, do you feel like legal advertising in Florida will change with the tort reform? And if so, how? Part one. And part two says, Along with that, do you feel that the awareness of tort reform will make consumers less likely to pursue a case?
I'm not an expert in what is going on right now, but we're all aware that Florida is looking to wreak havoc on claimants' lawsuits against, big pharma and other, medical device companies. We're also aware, however, that it is being fought by some of the largest law firms, most powerful law firms in the country. There's a belief that this is, violating constitutional rights. But yes, if that law were to stand, it's going to demotivate attorneys from going into that state and representing cases. It's going to demotivate plaintiffs from picking up the phone and still asking for help when they might really need it. I think the thing that these laws generally don't take into account is, number one, all the attorneys are working on spec, right? They don't know whether or not every case they sign is going to be a substantive case that will even make them their money back on what it took to take that case. Number two, if law firms were not offering this, where would these people get help? And the biggest thing that, aside from death cases and money then going to the estate, is in many cases where there's been severe injury, there's a lifetime of care, and the lifetime of care is part of the greatest impact to the case. So if you step on that, these people are going to suffer. And I believe that is the perspective of where law firms battling this are going to come from, in that people should have, listen, it's going to remove any sense of liability that the pharmaceuticals and medical devices have, at least for that state, and it could put people in severe health and financial jeopardy. So that is something we're all watching. And look, these laws are typically a administration away from changing one way or the other. How long a law like this, should it become law, would stick, I think would remain to be seen. But I think the fight that the state of Florida is heading for may be more than they are bargaining for, but it's going to be big. It's already started.
Well, let me jump back in here and close things out. Phenomenal session, guys. Adam, you're a fountain of knowledge on this topic, buddy. Thank you for joining us here today. Chris, Adam, great conversation. Well, folks, I hope you enjoyed today's conversation as much as I did. I learned a ton. Before we close out, I'd like to take a moment to invite each and every one of you to join us for our next episode of the PDMI's Take 20, hosted Wednesday, May 3rd at 11 a.m. Pacific, 2 p.m. Eastern Standard Time. I'd also like to remind you that PDMI's Fall Conference, PDMI West, is scheduled for October 9th through 11th in San Diego at a new hotel, the Intercontinental Hotel. For those planning to stay on site at the Intercontinental, hotel rooms are now available for registered badge holders at a discounted registered badge rate. To get your badges and or your hotel rooms, please visit thepdmi.com. That's thepdmi.com. Other than that, folks, we'll see you on the next episode of Take 20. Thank you so much for joining us today. Again, Adam, Chris, you guys are the best. Appreciate you.
Thank you so much, both of you guys.